Hey there, everyone. It's Rob Ryder on Friday, November 28th, 2014. And for those who hadn't heard, Rod Class is out of jail. In fact, I think he'll be doing a call later on tonight. But because he had been in jail over the last, mainly last week, I had been looking at the few things I could find in his court case that were online. And this is one of the pieces. Did a little research, and then I tried something on Friday, which would have been a week ago. And I don't know if that had anything at all to do with Rod getting out of jail. I don't know. He got out, I heard on his call, he got out on Saturday. He did the call on Tuesday. And what I had done on Friday, I said if they didn't let Rod out, I would do something else this week. And I was working on that, and then Rod's out. So I'm not making anything out of it than it is. It's all coincidental. That's great. But it doesn't change the fact that the things I'm going to show you are what they are, and let's just see what we can do with it. So, this was, so here's the case number. Now again, these are just a few documents that I could find online. I don't have access to Pacer. But the case number, document number, filed, what date it was filed. And so on the 20th of August 2014, the government put a motion in to dismiss a count. That's interesting. And I'm looking at this thing, and it doesn't take long to say, well, because I'm always looking for the errors, and boom, it's just full of them. Starting out with there's no plaintiff. It doesn't say there's a plaintiff. The United States of America is not the plaintiff. Where does it say plaintiff? If Rodney Class, defendant, then it should be United States of America, plaintiff. But they really can't do that because the United States of America is not the sui juris legal personality of the United States. And so what I mean by that is whatever name you can be sued in is the name that you should sue in. It's your sui juris legal personality. To sue or be sued in your proper person. And the proper person for the government is the United States if you can believe what it says on the U.S. Federal Court of Claims website, which says the defendant is always the United States. Well, if that's the defendant, then when they're the plaintiff, it should be the United States, not United States of America. United States of America is not the government. United States of America is a corporation that's usurped the government. But they're certainly not the defendant. Right? So whoever wrote this has just committed a official misconduct. Because, of course, it was going to be written by an attorney. And that's what all this comes down to, is this is things that attorneys have done, and as I heard Rod say, we should know their jobs. Well, I couldn't agree more. Not only should we know their jobs, we should know what to do about it when they don't do their job. And that isn't bitch to the people that you're in the court with at the time, because they're the ones that are doing it. They have a disciplinary board, and when you look closely at these disciplinary boards, they're under the for instance, I think it was Illinois had one of the better lines. It said the Illinois Supreme Court governs the practice of law within the state of or within Illinois. I don't think it said state. It said within Illinois. The Supreme Court, Supreme Court of Illinois governs the practice of law in Illinois. The Supreme Court governs the practice of law in the state of Michigan, right? The Supreme Court of Michigan. And you'll find that all the Supreme Courts are the ones that govern the practice of law. And so you don't go to the Yahoo you're dealing with in that court. You're going to take it to the Supreme Court. But they, as a judicial body, have created an administrative office to look for probable cause. And that would be the disciplinary board or grievance commission or whatever it's called. And we'll just see how that goes. But as you can see, when they wrote this, they went to, the United States by its attorney. Well, is it the United States or is it United States of America? Oh, there's no plaintiff. Jeepers. The United States Attorney for the District of Columbia, pursuant to Rule 48 of the Federal Rules of Criminal Procedure, hereby requests leave of court to dismiss Count 2, 22 D.C. Code 4504. Well, first of all, why is a federal court charging for a local ordinance violation, or the equivalent of a state statute? They can't. There's something wrong with the indictment, and luckily I was able to find the indictment. But so they wanted to take this Count 2 off of the indictment. Blah blah blah. Without prejudice, respectfully submitted Ronald C. Mackin, United States Attorney, and Jeff Pearlman, Assistant United States Attorney. You can see that the United States Attorney is all caps here, and Jeff is lowercase. Well, as it turns out, neither of these are the names that these gentlemen use or have certified to be their name, on the roll of attorneys within Washington, D.C. Ronald C. Mackin goes as Ronald C. Mackin Jr. on the roll of attorneys, and Jeff Pearlman goes as Jeffrey Pearlman. So, as you see these names here, neither of these names are authorized to practice law within the District of Columbia. And I saw that and I said, I'm going to put a complaint into the Grievance Commission of the District of Columbia. And so I started to do that. But then when I was looking, I could see that, you can email these guys when you find them on the DC Bar website, basically. Jeff Pearlman had an email address, so I sent him an email, which we'll look at in a second. So, I hereby certify a copy of the foregoing government motion to dismiss has been mailed, postage paid to the defendant, Rodney Class. Now, they want you to think that Rodney Class is the defendant. There is no Rodney Class. Right? Up here, it's uppercase Rodney Class, comma, defendant. Well, right, who's the defendant? The United States of America doesn't exist as the government, and this is supposed to be a criminal complaint. This isn't civil, this is supposed to be criminal. Rod broke a law. It needs to be the government. It needs to be the United States. It isn't. That's why they're going after Rodney Class, because both of these are fictitious entities. But it should be noted that it is contempt of court to sue in the name of a fictitious plaintiff. And the United States of America is a fictitious plaintiff. Plus, it doesn't say they're a plaintiff, so there is no plaintiff, so it is a fictitious plaintiff. This piece of paper simulates a legal process. Well, that would be color of law. Color of law is a civil rights violation. Not only is it a civil rights violation, it is an international crime against humanity. I've gone through all that stuff before. I'm not going to go show it again, but it's just things I've seen in the past, and I can remember that kind of stuff. Okay, so that was that piece of paper. Now here was the indictment that I found online. Again, I don't even know if this is correct, right? But somebody had it online, said it was Rod, so what the hell? Violations, 40 U.S.C. Okay, well, that would go with a federal court, federal statute. But 22 D.C. Code, whatever, is not a federal statute. That's a state statute for the District of Columbia. What is the United States District Court doing, charging for a state infraction? They can't. But it gets better. Indictment. The grand jury charges that, count 1, on or about. Stop. You don't need to go any further. If you go read the definition of an indictment, it says it's a definite statement, and on or about is not a definite statement. They know when Rod did this, they wrote him a frickin' ticket. Right? On or about doesn't work. No. Again, simulated legal process. And so these were the things I had found. So I got to, I'm going to try something. And on here, it doesn't show that they signed either. Attorney of the United States in and for the District of Columbia is supposed to sign it. So, first of all, they're charging for a a state statute, 22 D.C. Code, section 4504, and they're using the words on or about, which is not a definite statement. And these are really things I covered a couple years ago in a video I did called Indictment Shakedown. Shake, S-H-A-K-E, shakedown. But, it's not a definite statement. And so, I'll get rid of these now, if you don't mind. Maybe not that one. So I wrote, because I could, I don't know if you can see this, but last Friday, 11/21/2014, at 10:21 a.m. is when I saved it. I had actually written it because on the DC Bar website, it's just little blocks you're typing in. I don't type very good, so I need to spell check everything. So I was doing it in a Word document, copy and paste, and put it into the DC Bar. So I was probably closer to 9:30. And then at 10:21, I got all done and decided to keep it. And but for some reason, I got taken away from my desk, right? So early, I guess what I'm saying, earlier in the morning, comparatively, in Washington, D.C., I sent this email to, or by email, to the D.C. Bar portal to a guy named Jeffrey Perlman, in which I said, Jeffrey Perlman appears to be the name authorized to practice law. Yet you seem to sign papers as Jeff Perlman. See case, blah, 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 what we just looked at. That's probably why I saved this. Pop it up again here. Where is it? All right, so I was talking about this piece of paper here. Jeff Perlman is not authorized to practice law and is engaged in the unauthorized practice of law. Or Jeffrey Perlman, who is authorized to practice law, has committed an act of official misconduct. Right? There's two ways this can go. The fictitious man, Jeff Perlman, who he's not authorized to practice law. Jeffrey Perlman is, Jeffery, Perlman. He certified the name. He gave it, you have to certify your name yearly. That's the name he's using, Jeffrey Perlman. Yet he signed his stuff as Jeff Perlman. What that really is an attorney aiding and abetting a non-attorney in the unauthorized practice of law. But as it goes on, Ronald C. Machen is not authorized to practice law and engaged in the unauthorized practice of law. Or Ronald C. Machen Jr. who is authorized to practice law, has committed an act of official misconduct. Criminal number 13CR253RWR, which is, whatever this is here, where that came from, is a simulated legal process using color of law in violation of various acts of Congress, such as the Civil Rights Act of 1866, the same being the supreme law of the land. The acts of Congress are the supreme law of the land, and yes, you can use them. We must use them. We must say you're breaking this particular one. The nature and content of the form of the indictment in this matter does not conform to the Federal Rules of Criminal Procedures, Rule 7C1, which states in part, in general, the indictment or information must be plain, concise, and definite written statement of the essential facts constituting the offense charged. It must be signed by an attorney for the government. On or about is not a definite statement of the facts, and this instrument appears to be missing the required signature by an attorney for the government. Rodney Class is a fictitious entity, yet Rodney Dale Class, a living man, is now unlawfully imprisoned on a civil contempt charge for not appearing for a hearing in this matter. Rodney Dale Class has had his civil rights violated by a proceeding that could be construed as an international crime against humanity, in which Jeff and Ronald are co-conspirator defendants. See that Rodney Dale Class is released immediately and provide him transportation to his home in North Carolina or to another destination of his choice. See that all U.S. attorneys and their deputies use only the name authorized to practice law as required by the rules of professional conduct, and file a complaint against anyone claiming to be an attorney and counselor at law who does not use the name they are authorized to practice under. This is my attempt to come to my brother first, but if necessary I will file a complaint with the Office of Bar Counsel. Get Rodney Dale Class home now. Hey, I said it on Friday, early Friday morning. Rod's home on Saturday. I don't know what he got out of court, though. He never did say. He just said he got home Saturday. It's like, well, so we have to get down to the finer details, but it doesn't mean none of this is correct. All this is correct. And I decided I'm going to go to my brother first. I'm going to go to this attorney, point out the errors, have him fix them. At the time, I just wanted to see if we get Rod home. Right? We can go back at him now because I found all sorts of things we're not doing right. So that's what I had written, and then I was sitting there. Excuse me. That was on Friday. Didn't hear anything, and it was actually Tuesday. I was sitting filling out this piece of paper because I hadn't heard anything yet. Office of Bar Counsel, the Board of Professional Conduct, District of Columbia Court of Appeals, who has jurisdiction over the practice of law in the District of Columbia. Even if they're in a federal court, they need to be a member of this bar that's under the jurisdiction of the District of Columbia Court of Appeals. Simple enough to fill out, right? You put your name, address, yada yada, right? Attorney complaint of Jeffrey Perlman, address D.C. United States Attorney's Office. Where applicable, state the name of the court where the underlying case is filed. Okay, criminal case. Do you have any other documents? Yeah, I had a couple. 13 CF, which was the case in the District of Columbia. This 2013 CF2. This is the case that was in the District of Columbia that they dismissed. They dismissed the case completely. And this is, back last September. Then they made Rod come back in and get rearrested, and they put it in the federal court. But the District of Columbia court had dismissed the case. See the reverse side, details and so forth. This is interesting. They're using the back side of the paper, because really the front side is page 1, the back side is page 2, front side is page 3, back side is page 4. Might be important to remember that. Excuse me. At least, if you're going to leave it blank, write on it that it's blank. Violation of Federal Rules of Criminal Procedure, Rule 42, which is criminal contempt of court, use of color of law. These are details in the complaint. In violation of civil rights, professional misconduct, false personation, and a simulated legal process. That's what I'm complaining about. Government's motion to dismiss count 2, filed whenever, provided documentary evidence to substantiate complaint. 1. The federal government sui juris legal personality is the United States, not United States of America. Any prosecution for crime against the United States must be prosecuted in this name. Case whatever is a simulated legal process and could be construed as an act of treason. Plaintiff is not part of the caption indicating there is not a complainant. I guess I should have said. Rodney Class is a legal fiction and is not the living man, Rodney Dale Class. Rodney is not being prosecuted in his proper persona in violation of his civil rights. You want to sue me, you're going to sue Robert Allen Ritlewski. And when I see it on the docket, it better say Robert Allen Ritlewski, not Ritlewski, Robert Allen, which is what the docket's going to show. And they're not going to sue Robert Allen Ritlewski. They'd sue Robert A. Ritlewski or Robert Ritlewski or whatever, but they really don't want to have to touch that one if they don't have to. Our two attorneys here are participating in the unauthorized practice of law, because these aren't the names they're attorneys under. These names are not legal names found on your roll of members nor will they be found in any official role of attorney. However, Ronald C. Mackin Jr. and Jeffrey Perlman are both members and are committing professional misconduct, contempt of court, acts of treason, and countless other international human rights violations. The indictment in this matter is also evidence of color law and civil rights violations, as it does not conform to Federal Rules of Criminal Procedures, in which the definite, we already talked about that one, right? So, in the Federal Rules of Criminal Procedure, they have a thing for criminal contempt of court, right? So, you want to point out the rule that they're breaking. That was the point here. I'm going to point out this rule, if I was doing this, that they're in criminal contempt of court because they're using a simulated legal process. They brought contempt upon the courts. It's really that simple. But I never got a chance to send it, right? So I could have got this done in 2 pages. All right, now I was down to signing it, and somebody, I think it was Roe, sent me a Skype thing that said that Rob was out of jail, and I went and then I found out he had done a little video or audio, and I listened to it, and it's kind of where we are. So I don't know that any of this had anything to do with anything. I'm just pointing out what I think is a missed opportunity if you don't immediately. This is if you're in a foreclosure or whatever it is. When that attorney comes to you, you check immediately to see if the name he's got on his business card or whatever he signed is the name that's in the roll of attorneys. And if it isn't, or if it is. If it isn't, you have a complaint one way. If it is, you got a complaint another way. Because just last week, Jerry Stanton here in Michigan, maybe it was 2 weeks ago, said he had gotten served because he had put some liens on judges, which I don't recommend anybody do, and so he got served some papers, and now he's, oh my God, I got served papers. Well, there you go. Don't put liens on people. But he thinks that's the way that's his way of handling it. So, but what he sent me that he got served was a complaint. Well, when you read the procedures, what you're supposed to be served is a summons with a complaint attached to it. There was no summons attached to the complaint. Well, an attorney who looks like his name is proper, because I checked, well, this guy's using the same name here, and he's like for one of these attorney for a municipal organization of some kind. So it looks like he's using the same name. He doesn't have a middle initial. It's whatever, 2 words and 2 words. But the point is, he didn't follow proper procedures, and he didn't send the summons. So he's guilty of official misconduct. He's involved in fraud, and you need to point it out that you got served by this attorney, and there was no summons. You got served by this attorney, and there was no signature. And it doesn't look like he's using the name that's on your roll of attorneys. That's really all it takes. So what else can we find out? What else can we learn from this? Let me see what else there was. Okay, here's where it says United States District and Bankruptcy Courts for the District of Columbia, application for admission. This is a petition for admission to practice before the bar of this court. For you to be eligible for admission, the court requires that you be an active member in good standing of the District of Columbia Bar, or an active member in good standing of the highest court of any state which you maintain your principal law office, and are a member in good standing of the United States District Court that provides for reciprocal admission, blah, 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 blah. So, you Google District of Columbia Bar, it takes you to their website, you do a little looking, you say, oh, here's a way that I get to check for a member. You put the names in, see how the name comes up. I really didn't want to show anything about this other than the fact that we're talking about a United States District Court. But if you want to practice in that court, you got to be a member of the District of Columbia Bar, and the District of Columbia Bar is set up under the District of Columbia Court of Appeals. Now, I'll show you here. All right, here's Supreme Court, State of Arizona, Matthew John Bowles. Having exhibited to the justices of the Supreme Court of this state satisfactory can't remember what size I can make this. Make it just sit there. Evidence of good moral character and qualifications to practice law is therefore hereby authorized to practice as an attorney and counselor in the Supreme Court and all other courts of this state for enduring good behavior in said practice, in testimony whereof, blah, 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 blah. You got the clerk, chief judge, seal of the Supreme Court, State of Arizona. Looks pretty good. That looks pretty good to me. Well, what does he do for a living? Here's his website. Matthew J. Bowles. Was it Matthew J? No, it was Matthew John. Matthew John, you can't do it as Matthew J. Bowles. You're not an attorney. You can't call yourself an attorney unless you're an attorney. Maybe that was a problem. He was an Eagle Scout. That and his old man made him wear funny hats and cut the grass and got laughed at by the neighbors. So what does he do now? He takes your property. But we can see here that he's proud of himself. He's got his little this, that, and the other thing. How smart he is. But it's Matthew John Bowles. Matthew John Bowles. Matthew John Bowles. Matthew J. ain't got a damn thing. Matthew J. doesn't have a license to practice law. Yet Matthew J. Bowles has got a business saying that he's a frickin' attorney. He could have a bad day. I ain't got nothing against him, except that he's an attorney. Got other things to worry about. First of all, I got to see if this stuff works, right? So it's better to take one that somebody has a problem with and push it on through, see what happens next. What was I wanted to find something here. So, I was looking for, I had a court of claims case here to show how they did that. Where's that? Court of Claims defendant. Right? Here's a plaintiff, and the defendant is the United States. This is in the United States Court of Federal Claims. Savantage Financial Services Incorporated plaintiff versus United States defendant. There's a plaintiff. How come there's no plaintiff in a criminal case? I think I believe that to be a requirement of a caption to list who the plaintiff is. Now here's one that's incorrect. This is interesting, right? Because they don't do them. If I was Gordon James Klingelschmidt, plaintiff, I would be kicking my attorney's ass for putting the United States of America because he didn't read the rules. It says in the rules the defendant in this court is always the United States. Actually, it says it on the pro se page where it's talking about you putting a complaint in to the United States Court of Federal Claims, and you click the complaint, learn or information on a complaint or whatever it is, and go down to the bottom and it gives some terms you should know. And there's one of them, who a defendant is. And in this court, the defendant is always the United States, is what it said. This goes even further, right? Because we got judges. But we don't have judges. Because I, Elizabeth K. Flood, do solemnly swear that I will support the Constitution of the United States, the Constitution of the United State of Illinois, and I will faithfully discharge the duties of Associated Judge, Circuit Court, 16th Judicial Circuit of Illinois, according to the best of my ability. That's what she declared. Declarance. A declaration is an unsworn statement. Signed by another judge, Judith M. Brokaw, who's supposed to says she's the chief judge, but there's no seal. We don't really know what she's the chief judge of. The way this looks, she's saying she's the chief judge of the Supreme Court of Illinois. But I don't think she is. Well, what does that got to do with anything? Well, it has this to do with it. When you go to the ARDC, which is the Illinois Attorney Registration and Disciplinary Commission, created by the Supreme Court that governs the practice of law within the state, you find their full license names are Elizabeth Kathleen Flood and Judith Mary Brokaw. So we put complaints into the ARDC about these two judges, and they wanted to come back and say that, you know, for judicial matters, you got to go to this other agency, which is true. But what we're saying is, Elizabeth Kathleen Flood isn't the one who became an attorney or became a judge. Elizabeth K. Flood, who was never an attorney, therefore she could never be a judge, therefore there was never a judge. This isn't a matter of official misconduct. This is false impersonation of a judge. And everything that she's ever touched has to be undone. Let's empty the jails today. Elizabeth K. Flood was never an attorney. Therefore, she could never have been a judge. This is just the usurpation of an office. Now, maybe the proper thing is to take it to the judicial people to have them deal with it, but it doesn't change the fact that Elizabeth K. Flood is not a judge. No, she's not. And neither is the lady claiming to be the frickin' chief judge, Judith M. Brokaw. She was never an attorney. Therefore, she was never a judge. Now, they don't hide this stuff. Right here, this is something I pointed out in one of my earlier videos talking about this stuff. General bar admission for new Illinois attorneys. Please note that no swearing-in ceremony will be held. Instead, petitioners have an oath of office notarized. Duh! Yes, you have to swear to your oath. Right? You can't just go there and raise your hand and do a ceremony. There's no memorial to the event. You have to subscribe an oath. Right? That's what that's what these guys are trying to do here is excuse me. They were subscribing an oath. The undersigned, being duly authorized to administer oath, certifies that the foregoing oath of office was administered to the declarant on the 25th day of January 2013. Excuse me. Well, if that's the case, then she didn't do it as a chief judge, she did it as a notary. Because Judith M. Brokaw was never a frickin' attorney, so she could never have been a judge, so she could never be duly authorized to do anything. Unless she's a notary under that, because I think when you do notary paperwork, to become a notary, they want you to use your middle initial. They demand you use your middle initial. But you see, they have to, in this bar, they have to certify their name every year. Certify their name, certify their address, and certify this account that they use for their client and third parties' property. Well, if their client is their client, then who's the third party? That would be you and your property. What did I say? Affidavit of sponsor. They have to have a sponsor. Please sign the oath of office on the last page and have it notarized. Notarization replaces being sworn in by a judge. No ceremony will be held. Doesn't matter who swears you in, unless you subscribe an oath, there's no memorial to the event. Right? You can tell me you were there, but you can't prove you were there. You can tell me I'm a citizen of the United States, but you can't prove it. I don't have a certificate that says I'm a citizen of the United States. Now here's some notes of interest. Just things I found as I was going through this stuff. So this is like Arizona. It says the Supreme Court jurisdiction over the practice of law. Any person or entity engaged in the practice of law or unauthorized practice of law in this state as defined by these rules is subject to this court's jurisdiction. Which court's jurisdiction? The Supreme Court jurisdiction. Unauthorized practice of law includes but not limited to engaging in a practice of law by persons or entities not authorized to practice pursuant to paragraphs B or C or specifically admitted to practice, yada yada yada. Using the designation, this is under the unauthorized practice law, number 2. Using the designation lawyer, attorney at law, counselor at law, law office, JD, esquire, or other equivalent word by any person or entity who is not authorized to practice law in the state pursuant to paragraphs B or C, or specifically admitted, blah, 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 blah. And B or C, although this is, I'm going to go on to Indiana now, those were, basically if you're committing a crime. Things to do with committing a crime. Rule 1, Bar of Indiana. The bar of this state shall consist of all attorneys in good standing who, prior to 31, were duly admitted to practice law in the circuit courts of this state, and all attorneys in good standing who, subsequent thereto, have been or hereafter shall be admitted to practice by this court. All attorneys in active or inactive good standing, duly admitted to the practice of law in the state of Indiana, shall file with the clerk of the Supreme Court, 216 State House, Indianapolis, Indiana, their correct name, office, residence address, office telephone number, electronic mail address, county of residence. Said attorney shall notify clerk of the Supreme Court of any change of address, including electronic mail address, change of telephone number, change of name within 30 days of such change. A notice of change of name shall be accompanied by a copy of the court record or an affidavit that states the name change. The name and address so filed shall be effective for all notices involving license as attorneys or disciplinary matters, right? What name they care about? The one that you give them, that they certify. The clerk shall annually send a certified list of attorneys together with their addresses on file to the Indiana State Bar Association. And so when you go to the Indiana State Bar Association, you can look up attorneys there. I don't know if you can or not. Michigan's you can. Right? That you should find the name that has been certified by the clerk being used there. But if you really want to make sure, you get a hold of the clerk of the Supreme Court and ask her. Which Bob in Arizona did, because he had a problem with an assistant city attorney, and he called and he's talking to the clerk's office at the Supreme Court of Arizona. It says, whoever it is, middle initial, an attorney on your roll of attorneys? And they went and looked, said, no, he's not on our roll. And Bob says, well, how can that be? I'm looking at the City of Surprises website, and he's listed as the assistant city attorney. Can you please go look again? Came back a minute later. No, he's not on there. I said, well, what am I supposed to do or whatever? I can't remember. He said, well, you should call, and gave him the number of the judicial group that handles it for Arizona. Now, he hasn't sent them a complaint yet because we were doing some other things with understanding that the city manager is he's the top law enforcement officer in the city. His job is to enforce all laws and ordinances. And so, because Bob had gotten a ticket from a city policeman who's under the city police chief, who's under the city manager, who's tasked with enforcing all laws and ordinances, we took our complaint to him to find out, number one, it says in Arizona you're supposed to lay your complaint before the proper magistrate. Who'd you have in mind? City attorney, city manager, because it looks like your city policemen are engaged in either official misconduct or the false personation of a peace officer, because only a peace officer can arrest you. Only a peace officer can arrest you. Only a peace officer can arrest you. Anybody else arrests you, it's official misconduct or false personation. And if a peace officer arrests you and he doesn't put his name on the paperwork and the badge and the other stuff, well, that's official misconduct. And so that's what we're trying right now. And, the holidays get in the way. What are you going to do? Have to wait and see. What did Wikipedia say about the practice of law? Attorney participation. In the United States, the rules of professional conduct generally prohibit an attorney from assisting a non-attorney from engaging in the unauthorized practice of law. This is the split personality of the guy who is the attorney and has access to all this information, using it as a non-attorney, middle initial name, and he got the information from the attorney with the full name. Because, there's things that only the attorneys can have access to. They won't let you have access to them. You're not an attorney. But they're not signing their papers as an attorney, but they're using their access because they are an attorney to get access to certain information. Now, before I forget, I don't even know that all attorneys have actually sworn an oath. Can't overlook this. When Roe was sitting there with her public defender, and we had first come across this stuff, and she had a chance to ask her some questions, she asked the lady if she had ever sworn an oath, and the lady said no. She went to a ceremony, right? They didn't sign anything, just swore. Yeah. There's people who say they're attorneys that have never been, never will be attorneys. And they're working as the public defender's office. I don't know where else they're working, but that was an example. So every state then, whatever the organization is that has jurisdiction over the governing the practice of law within the state, they're going to have a code of conduct. And this must be kind of a universal thing, because I looked at 3 or 4 or 5 different states, and Section 8 has to do with reporting official misconduct, and Section 5 has to do with what official misconduct is. Right? But Section 8.3 says a lawyer who knows another lawyer has committed a violation of 8.4 or 8.4 shall inform the appropriate professional authority. And that's why I wrote what I did to the Jeffrey. Okay, attorney, I've just pointed it out to you. If you see any other violations, you have a duty to report it. I don't need to report it, you do. I'm going to report your ass for not reporting it, and then report it. A lawyer who knows that a judge has committed a violation of applicable rules of judicial conduct that raises a substantial question as to the judge's fitness for office shall inform the appropriate authority. Well, the middle initial was never a lawyer or an attorney, so they never could have been a judge, yet there they are, sitting up there. Attorney, lawyer, I don't care what you call it. I'm pointing it out to you. You go do something about it. I'm going to point you out, and then I'll point that out. Misconduct. We got some ideas what that is. Commit a criminal act that reflects adversely on a lawyer's honesty, trustworthiness, or fitness for a lawyer in other respects. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. This goes back to that first part up here, where it was talking about the B or C, engaging in the practice of law, right? And so here's the follow-up. Commit a criminal act that reflects adversely on an attorney's honesty, trustworthiness, or fitness. Well, a criminal act would be not to follow the procedures and fill in the paperwork out, or send in the summons. You can't just send a complaint. That the whole idea of the notice is to send a summons that you've been summoned to court. Excuse me. That would be engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. Somebody's got a bad day. See what they're acting as. They're not acting as an attorney at law, which can give you legal advice. They're acting as an attorney in fact, a private attorney authorized by another to act in his place and stead, either for some particular purpose or to do a particular act. Right? They become you. They represent you. They become you. They're not giving you legal advice. They're going to become as dumb as you are, as far as the law is concerned, and sign their name. What line you want me to sign it on? They want to be an attorney in fact, because anything you sign with them is going to give them power of attorney. If there's a power of attorney involved, it's an attorney in fact. Attorney of record, whose name must appear somewhere in the permanent records of a case, because eventually somebody has to be responsible when we figure this out, so that their certified bank account that has all these funds in it can be tapped to get your property back out of. So like in a foreclosure, the very first paperwork you're going to get from them, there's going to be an attorney of record listed there. Has a particular name. And when you read the frickin' the civil procedures, it says that the attorney of record must be in court at the hearings. You go to court, and that's not the attorney of record sitting there. In fact, it's a different attorney. Could be 2, 3, 4 different attorneys sitting there, depending on what day of the week it is. It's because you're in the wrong court. It's not the court you're supposed to be in. Oh, you didn't get the notice. Damn it, I forgot to mail it to you. But I certified that I sent you one. I must not have had your proper address. It's the kind of games I play. D.C. Bar, since its creation by the District of Columbia Court of Appeals in 1972, the D.C. Bar. D.C. Attorney Disciplinary System, District of Columbia Court of Appeals, Board of Professional Responsibility. The District of Columbia Court of Appeals has the ultimate authority for disciplining members of the District of Columbia Bar for violations of the D.C. Rules of Professional Conduct. Right? You got anything going on in D.C., you want to go and understand that the District of Columbia Court of Appeals has the ultimate authority for disciplining members of the District of Columbia Bar for violations of the D.C. Rules of Professional Conduct. So, of course, you're going to go look at their D.C. Rules of Professional Conduct and point them out. Because this is like these bar associations, and that's what they are. They're associations. They're like private membership. Right? Call them whatever you want, close shop, whatever it is, but it's a members-only club that has its own set of rules, and they have agreed to those rules, plus all the other rules, but specifically these rules, such as the D.C. Rules of Professional Conduct. The process is governed by Rule 11 of the Rules of Court of Appeals governing the bar. Jeepers. It's going to tell you how it works. Generally provides that all members of the D.C. Bar, those making limited appearances, and others admitted to practice are subject to the disciplinary rule. Excellent. They got a board of professional responsibility. Yada, yada, yada. The District of Columbia Court of Appeals has inherent jurisdiction over members of the legal profession in the District of Columbia, including matters of attorney discipline. Hello? Hello? Don't go anywhere else but the District of Columbia Court of Appeals. And you're going to go to them through their administrative hearing office that they have set up to see if there is probable cause for an investigation. And that's, well, that's who, where is that thing at? That's who these guys are. Office of Bar Counsel. The Board of Professional Responsibility, District of Columbia Court of Appeals, right? They set this up as the input where you bring in your complaint against an attorney to have it investigated, to look for probable cause. If there's probable cause, then, it's back to the fleet for that particular character. Person subject to disciplinary jurisdiction, all members of this... I already read that, right? If you practice in law in D.C., you're going to be under their jurisdiction. Because this is the only bar that is mandatory. Jurisdiction of other courts and voluntary bar associations. Right? So there are voluntary bar associations. Here's grounds for disciplines and the duties of an attorney. The license to practice law in District of Columbia is a continuing proclamation by the court that the holder is fit to be entrusted with professional and judicial matters and to aid in the administration of justice as an attorney and an officer of the court. That makes him a public officer. It's a whole new ballgame. Misconduct, acts, or omissions by an attorney, individually or in concert with other persons or persons, who violate the attorney's oath of office or the rules or code of professional conduct, currently in fact in the District of Columbia, shall constitute misconduct and shall be grounds for discipline, whether or not the act or omission occurred in the course of the attorney's-client relationship. So you don't have to have nothing to do with you and the attorney. You don't have to have a relationship. You just point out the errors. The errors and the omissions. They didn't sign the paper. They didn't serve the documents. They're not using their right name. You don't know really, you don't need to go any further than that one. I mean, you can point out all the stuff you want, but make sure you point that out early. Because they don't want to read 15 pages of crap. Get it on, get it decided with. Here's a voluntary bar. The Bar Association of the District of Columbia, which is different than the District of Columbia Bar. This one is voluntary. Congress established District of Columbia Court of Appeals as the highest court in the District of Columbia in 1970. The court consists of a chief judge, 8 associate judges. The court is assisted by the service of retired judges who have recommended or approved by senior judges. The D.C. Court of Appeals is equivalent of a state Supreme Court. Now that's very interesting. That says lowercase state Supreme Court. The D.C. Court of Appeals. Well, the Michigan Court of Appeals, their seal has the Great Seal of the state of Michigan as part of the seal. But the Michigan Supreme Court has got, I'll show you. It's better to show you. Hang on just a second here. Stop. Okay, I don't know if you can see this, but here on the left, this is the Court of Appeals of the state of Michigan. And it's got the Michigan Great Seal in the middle of it. This one here in the middle, this is the seal of the Michigan Supreme Court. It looks like, I don't know, somebody that was the entertainment at a toga party. I don't know. But it isn't the Great Seal of the state of Michigan, so I don't believe that this seal of the Michigan Supreme Court has anything to do with the Supreme Court of the state of Michigan. That this is the Supreme Court of the state of Michigan, this Court of Appeals of the state of Michigan. And this goes all the way back to the territory stuff, where when Michigan was first made into a territory, the night before the governor and 3 judges showed up was the Great Fire of the city of Detroit. Burned down the whole city. They come in the next day, hey, we'll take care of it. We'll write new deeds up, and we'll resurvey, and we'll take care of it. Don't worry about it. And then they dispersed. Eventually, they got another judge in, I think it was. So they had these 4 judges, and they split the state into 4 pieces. And each of those judges sat as the judge of a district, and he rode a circuit in the district. And then they would get together in Detroit a couple times a year to make the Supreme Court. And then they would get together with the guy who was there as the governor and make the legislature. And so they had 5 guys that were the courts, the governor, and the legislature. The executive branch, the judicial branch, and the legislative branch. But there never was a state of Michigan, because they never split the Northwest Ordinance correctly. It's just go read the Northwest Ordinance. It's supposed to be split into 3 states, the eastern, the central, and the western state. And it says on the lines they're supposed to be divided on, and that isn't how they did Ohio. So from the beginning they did it incorrect. Not that any of that matters, but if you want to understand why there's all these different jurisdictions, that's what we're dealing with, is multiple jurisdictions. Okay. So, anyways, it's the equivalent of a state Supreme Court, whatever it is. The court also has jurisdiction to review decisions of administrative agencies, boards, commissions of the District of Columbia government, as well as to answer questions law certified by federal and state appellate courts. Questions of law certified by federal and state appellate courts. Why would a federal court send to the D.C. Court of Appeals questions on law certified? It don't make any sense. Or state appeals courts. Unless this is the state Supreme Court, and that's what it is, because this is the District of Columbia. It has nothing to do with the states. This is federal territory. I live in a jurisdiction that should be the basic republic, which is a township. And this is, a township less than 10 miles square, a district less than 10 miles square. Excuse me, the ideas of Thomas Jefferson in the 4 tiers of republics, with the most fundamental being like basically wherever there was a one-room schoolhouse, whatever district, whatever area was around that schoolhouse, that they said this is the area of that schoolhouse, that was a township. It's not necessarily a survey township, I guess what I'm saying. In the exercise of its inherent jurisdiction over members of the legal profession, the court established the District of Columbia Bar. Didn't say, again, in the exercise of its inherent jurisdiction over members of the legal profession in Washington, D.C. No, the legal profession, period. Well, comma. The court establishes the District of Columbia Bar. It's interesting. The District of Columbia Bar is a mandatory bar association of the District of Columbia. It administers the admission, licensing, discipline functions for lawyers licensed to practice in the district. It is to be distinguished from the bar association of the District of Columbia, which is a voluntary bar. Okay. Here's an example of what you would find, again, full licensed name, Elizabeth Kathleen Flood. But signed her oath, Elizabeth K. Flood. Not the same person. And that, it's as easy as this. This is what a form looks like. You don't need to get real fancy, right? If you want to read the words, I'll stop here for just long enough. You can hit pause and read it again. If you think it's something you might want to use, don't call me and ask me for a copy. Just copy it down, take a minute, write it down, and type it up so you make it yours. Just remember, the federal government's sui juris legal personality is the United States. And you can say, just go look at the Court of Federal Claims and tell me who the defendant is, and you need to sue and be sued in the same name. So it's either the United States or it's the United States of America. But it needs to be the same in both places. And on the Federal Court of Claims, it will tell you in the pro se section that the defendant of this court is always the United States. We'll go look at that real quick. U.S. Court of Claims. U.S. Court of Federal Claims. Filing a complaint. Pro se information. General information. To file a complaint. References. Legal terms you may encounter when filing your complaint. Defendant, the party whom the complaint is made. In this court, the defendant is always the United States. Plaintiff, the person bringing and prosecuting a civil action. Lowercase civil action. What else do I want to look at since I was here? Excuse me. I guess nothing else. I think that's about it anyways. Okay, so you get the idea. I don't know if what I did had anything to do with getting Rod out. That isn't the important thing. The important thing is, I hope it is. That would be important. Don't get me wrong. But the idea that look at the names of the attorneys and see if they're using a middle initial, if they're using a full middle name, if they got junior behind their name, if they got a hyphen in their name, what did they do different? Because Jeffrey Perlman appears to be the name authorized to practice law, yet you seem to sign papers as Jeff Perlman, and that would be incorrect. Jeff Perlman is not authorized to practice law and is engaged in the unauthorized practice law. Or Jeffrey Perlman, who is authorized to practice law, has committed an act of official misconduct. It doesn't get any simpler than that. You're either guilty of a Class 4 felony this way or a Class 4 felony that way. All I know is it's criminal contempt of court, and it should be, according to Lord Coke, time for you to go back to the fleet. 30 days in the brig, back to the fleet. Ronald C. Macon is not authorized, and this guy is supposed to be the U.S. Attorney for the District of Columbia. We have to see if he's still there. Rodney Class is a fictitious entity, yet Rodney Dale Class, living man, is now unlawfully imprisoned on a civil contempt charge for not appearing for a hearing in this matter. You know, on a civil contempt charge, they can hold you forever until you clear the contempt. Now, it's kind of impossible for you to clear a contempt if you're sitting in jail. So if you ever get a contempt charge, the first thing you want to do is ask forgiveness. Please forgive me if I'm somehow in contempt of this court. I didn't get proper notice of these proceedings, and this kind of pissed me off, and I may have blown my gasket. Forgive me. All right. Is this man doing business under his assumed name, or can he produce his certificate of good standing as an attorney so we can find out what name he should be signing these papers under? Because I believe that this is a simulated legal process, and that would be a civil rights violation and an international human rights crime. Good enough. You all have a great night. I hope you found it useful. Talk to you soon.